going to get started. We want to stick to our schedule and wrap up for everyone by about 8 o'clock. So thank you all again for being here. You have just joined the Balancing Act, the Sandwich Generation Realities Part 1 of a 6-part series brought to you by your local care collaborative, which includes myself, Maeghan Scott, Tez Roro, and Connie Pizarro. So we'll each take a quick moment to introduce ourselves before we dive in.
The bloodstream. Instead, the fat is deposited around the upper body, causing lumps called lipomas.
You can mute them.
Yeah. Okay. And we just ask that you keep your lines muted while we're on the Zoom. Thank you. So once again, my name is Maeghan Scott, and I'm the owner and operator of Right at Home of Essex County. We have been family owned and operated out of West Orange for over 21 years. And we provide in-home care to seniors and adults in all of Essex County. Our aides focus mostly on personal care, but we actually recently launched a new program called Enrich that allows for shorter visits with focus on companionship, mental stimulation, engagement, and fun. So I just wanted to share a quick story with you all. So my dad actually first started our business 21 years ago. And about 8 years ago, he actually got sick and he was hospitalized until he passed away. And there actually came a point during that hospitalization where he could no longer communicate his wishes or desires. And it just so happened that when I was in college, I actually took a sociology course called the Sociology of Birth and Death. And we had to do a project where we had our parents fill in a 5 wishes advance directive document. And so my mom actually held on to that document for all those years. And it turns out that when my dad was sick and in the hospital, this was actually the only thing that we had to go by to know what he desired at that time. And that was a homework project. So I tell you that because we were not prepared. We got lucky, but we want to make sure that you're all prepared. And I hope that this session really helps you to see the importance of being prepared and brings you all clarity regarding next steps that you can really take to protect yourselves and your loved ones. So I'm going to pass it over now to Tez for her introduction.
Thank you so much, Maeghan. Very heartfelt story and very relevant to what we're talking about today. My name is Tez Roro. It's great to see some familiar faces as well as some new faces. I'm a real estate broker and instructor, and it's really fun to always collaborate with Maeghan and Connie because they too, like me, are walk the talk rather, right? We come up with ideas, we actually implement it. So outside of the real estate sales, right, the typical sales that you may be familiar with, I hold a designation called SRES. It stands for Senior Real Estate Specialist. In order to successfully earn this designation, a realtor must demonstrate the necessary knowledge and skills to counsel clients age 50 plus through major financial and lifestyle transitions. And we started the series under the sandwich generation sort of theme because we are that sandwich generation. We are the adult kids supporting, our parents and perhaps kids or, give care in both directions. And the reason why an SRES may be valuable is we help you walk through the living situation with a customized approach and work to fit your living needs with the overall plan and consistently provide expertise and patience throughout the real estate transaction and understand the emotional aspects. Real estate, especially residential real estate, especially when we're dealing with sandwich generation, is quite emotional, and also provide options and network of solid, reliable referrals, such as the ladies that are here with me who are really top-notch in all that they do, and offer you a variety of choices. So I'll be here listening in, also monitoring the chat and helping facilitate this. And I'm excited to introduce Connie, who is the trio of this collective.
Good evening, everyone. It's so good to see everyone. I am Connie Pizarro, and I am the CEO of Oasis Senior Advisors, which is a franchise, and we are located in Piscataway, New Jersey. However, we service within central New Jersey. Our mission is to empower people to navigate the complex realities of aging. And we do this by providing did you get that? Free services to seniors and their families to help them to understand resources available to them when they can no longer live safely at home. I am a certified dementia practitioner, And that helps me with working with the clients, and that I can help the adult children to understand the complexities of dementia, how to care for their loved ones who have dementia, and the steps that they need to plan for before it becomes a major issue and you're looking for guardianship. So I am so happy to be a part of this trio. I believe we started working together maybe last year, a couple of 3 years ago, individually in working with each other, and then we just came together as a trio, and it has been a joy. So right now, I want to introduce to you our speaker for today is a dear, dear friend of mine. She is Crystal West Edwards, and she is a principal within the Wealth Preservation Group within Porzio, Bromberg Newman Attorneys. So she specializes and has extensive experience in the areas of elder law, special needs planning and advocacy, estate planning, and estate administration and counseling. She is highly experienced worker with legal problems and aging individuals and those with disabilities. Crystal counsels seniors, individuals with special needs, and their families with issues pertaining to complex estate and tax planning, asset preservation, eligibility for means-tested government benefits, fiduciary appointments and representation, and advocacy. She is also a trusted advisor to financial institutions and corporate fiduciaries with judicial and administrative accounting and counseling regarding initial and continued means tested government benefits eligibility for trust beneficiaries. That's a mouthful. So, needless to say, this lady knows her stuff. She is a sought after speaker, and she has authored numerous publications on the topics of elder, disability law, estate planning, special needs trust, and government agencies. I want to state some of the recognitions that she's received. She's been recognized by the best lawyers in America for elder law, trust estate, trust and trustee and estates. She's been recognized as the top 50 women in America. She has membership in the National Academy of Elder Law Attorneys, where she was the past president, and she was also a member of the board. She is currently serving as the co-chair for Diversity, Equity, and Inclusion Committee. She is a member of the Garden State Bar Foundation, where she serves as on the board of directors, and she is the past president. She's also a member of the National Bar Association. In her personal life, she is a member of Cathedral International in Perth Amboy, New Jersey. She is also a member of Alpha Kappa Alpha Sorority Incorporated, a member of Jack and Jill of America. I also want to mention of all of her accomplishments, I think the thing that she holds her pride and joy is being mother to Derek and Eva, along with being married to her husband, Derek. So I will present to you now and turn this over to Crystal West Edwards. If you have questions during the presentation, please put them in the chat. We will be monitoring the chat and addressing your questions as we go along.
Thank you, Connie. So first, Connie's taking advantage of the fact that we're on Zoom. So here's a little story for the family. I'm gonna call everybody that's on this call the family because we're gonna get really personal tonight. So back in the day, pre-COVID, the time that we don't even remember anymore, when we were in person, I used to threaten Connie and I would say that I will pick up my pearls and I will leave if she reads my bio, right? And I don't think she remembers that. And I can't really pick up and just leave. And she knows I'm not just going to exit the Zoom. So she made me sit through that. But I told her all she had to say was, this is Crystal, she can help you, right? That's all you really needed to know. But thank you so much, Connie, for that. For the folks that are here, for the family that's joined us, some of you are familiar faces, some of you, this may be our first time meeting. So I would love If you had things that were on your heart or that you were curious about or were concerned about when you saw the flyer and you saw the promo for tonight's discussion, can you just take a moment to drop it in the chat? Whatever it is. I don't want my kids to get nothing. Or I really want to make sure that my grandchildren are going to be okay. I'm worried about what'll happen to my house. I want to make sure that I've connected with the right people when it's time for my mom to go to a care facility. Whatever it is that led you to join tonight, if there was something that you had a question about, just drop it in the chat because I will then make sure that I can incorporate some of those elements if we were not already covering them for you. All right. Okay, so here we go. We're gonna kind of go through the estate planning, wealth building, asset protection, aging considerations in two parts, right? We talk about oftentimes when someone hears about estate planning, they're thinking about how we want things structured so that our assets will pass to the people that we want it to at our death. What we'll learn throughout today's discussion is that a part of it also requires us to think about how we have things structured during lifetime so that if certain events occur, we're prepared. If you can give me one quick second, because for some reason my PowerPoint has decided that it does not want to move. So I just need to move the chat around. Okay, got to close the chat. All right, here we go. So, what is estate planning? Now, let me just kind of set this framework. As the sandwich generation, we are dealing with two populations, really three populations of people all at the same time, right? Ourselves, the generations before us, and the generations that come after us. And regardless of where you are in life cycle, there's going to be at least one, sometimes two, whether it's two going up or two going down or one in each direction that ultimately you're planning for and you're concerned about. And I'm just looking at the note here in the chat. No more about trust and ensure my mom has a strong standing will. Okay, perfect. Gotcha. Okay. So on the estate planning front, this is age agnostic. When I came home from our honeymoon, my husband and I got married about 14 years ago. We came back from our honeymoon. We had chick nor child. We had nothing but student loan debt at the time. And I handed him a package of estate planning documents, and it included all of the things that you see here on this screen. A general durable power of attorney, an advance directive for healthcare, funeral instructions, or the appointment of a funeral representative, and a will. So if someone says, hey, I don't have an estate, well, yeah, true, because you're not dead yet. But if someone says, I don't have anything for which I really need to plan for, or what does it really mean for me to do estate planning? We're really talking about having these four core documents. The reason why I put will/trust here, and we're going to talk about trusts in more detail, and I did see a note in the chat that said that there's that at least one person wants to know more about trusts and how they work and whether or not they're appropriate for your family structure. Trusts come in many different flavors for different reasons. So for some families, a trust is an honorable mention. It's not required, but it's good to have in certain circumstances. For other family structures, it's required. But suffice it to say that for the two parts of this discussion, the first part is going to focus on the estate planning documents, and then the second is going to focus on ensuring that we actually have money to pass when we die, right? So, general durable power of attorney. In my world, this is one of two of the most important documents. Wills, state law says what happens if you don't have a will. And if you don't like that, then make sure you have a will. But when it comes to the things that can happen during lifetime that could derail our best laid plans or that could bankrupt us, for example, right? We want to have the opportunity for someone else to be able to stand in our shoes and make decisions for us if we can't make decisions for ourselves. And a general durable power of attorney will do just that. It is a document that you are signing where you're authorizing someone to make decisions. And what makes it durable is that it is effective now, but also it is effective at a future time that you may become incapacitated. As a practice point, a lot of people are interested in powers of attorney that are not effective until the date in which you can no longer make decisions for yourself. I don't love that type of power of attorney. It's called a springing power of attorney. Usually in my practice, I'm dealing with, I do a lot of pre-planning, but the reality of my practice is that a lot of clients have events that happen that we weren't expecting. And when we're not expecting them and the mortgage is due in 3 weeks, we really don't have time to fight with the legal department of fill in the blank bank, because I don't want to discriminate since we're recorded tonight and some of you may work or bank at those places, right? I don't want to then have to fight with a legal department to meet their standard of proof as to whether or not the person who needs someone to assist them is truly unavailable or incapacitated in such a way that they can't do it themselves. So a general durable power of attorney is typically my practice preference. An advance directive for healthcare is the second most important document in my world. Advance directives in New Jersey are two-part documents. You do not have to have both parts. It is totally fine if you only have one. But when you hear someone say, I have an advance directive or a combo directive, that's a directive that does two things. First, it says who you want to be your mouthpiece to make medical decisions for you if you cannot make them for yourself. And the second is the instruction directive, whereby you're saying what you want to occur. If death is imminent and I am in a terminal condition such that my doctors do not feel that there is a clinical likelihood of my recovery, I wish for life-sustaining treatment to be withheld and withdrawn, right? So that's what would be included in an instruction directive. Now, I have two slides here about medical aid in dying. And hopefully somebody is sitting at home saying, I don't know why that lady just put this up here on this screen. Why are we talking about medical aid in dying when we're talking about estate planning? Well, the reason that I felt it's important to include these two slides here is because for the last year of the 17 years I've been practicing, I have at least one client ask me about this every week, which was not the case 10 years ago. It wasn't the case 5 years ago. But right now, my clients want to off themselves. I'm joking, but I'm kind of not joking. So I just want us to understand what medical aid in dying is, because it is something that we do have in New Jersey, where an adult, right? So you have to be an adult that has capacity. So it can't be someone who can no longer make decisions for themselves, which, by the way, for those that have neurological illnesses such as dementia or Alzheimer's, right? Those may not qualify because someone has to have capacity still, meaning they have to be able to independently make their own healthcare decisions. An attending physician and then also a second consulting physician has to determine that the person is terminally ill. And in order to obtain the medication to end your life, you must be able to self-administer. A person who wants medical aid in dying must be able to say orally, so vocally, that they want such medication, and they also would have to say in writing to their physician that they want the medication as well. And just understand that because this law is only effective for someone who has capacity, you saying in a medical directive that you authorize your agent to make that decision for you is not enough. Again, I mention that particularly in light of the population that we're dealing with, and people live longer, and we have a significant amount of people in the US and in New Jersey that have Alzheimer's diagnoses, they have dementia diagnoses. And one of the things about death with dignity, which is what New Jersey actually called its Medical Aid in Dying Act, was death with dignity. A lot of my clients that have early onset or have an early diagnosis will come in and will say, Crystal, I want this.
Okay.
I don't want my family to have to take care of me. I don't want my kids to have to see me like that. Can't we do something? And I'm like, nah, Crystal, we can do it. I read it, right? And then I'm like, well, maybe you want to go to Oregon or like another state, but New Jersey is not the place for you. So I mention it just so you have the information. But back to our regularly scheduled program. What happens if you do not have that power of attorney and you do not have that medical directive? So you haven't authorized somebody to act on your behalf. You have not given someone the authority to make your legal, medical, and financial decisions for you. The end result to that is that the only person or place that could authorize someone else to act for you is a judge by way of a guardianship application in court. I don't want us to get confused by terminology. If you watch the news, sometimes you'll hear the term conservator, sometimes you'll hear the term guardian. Generally speaking, they're talking about the same thing. However, in New Jersey, those two terms are very different. A conservatorship in California, aka Britney Spears and them, is the equivalent of a New Jersey guardianship. We do have conservatorship, which is for people who have capacity that want to ask the court to appoint someone to make decisions for them. But ultimately, that type of appointment is fairly rare. I think I've had 3 clients request it since I've been in practice. But it is something that we use when we know that we're having diminished capacity. Maybe even it's something that we do when we want someone to serve, but we may not fully trust them. So we want them to serve with some court oversight. That's another reason why someone would choose guardianship. Guardianship involves 2 doctors and 2 lawyers, so it's expensive and we want to avoid it. And you can easily avoid it in a lot of situations by planning in advance and having a power of attorney. Is it fail-proof? No, it is not. What I mean by that is if you have, well, let's pick on my kids. I've got 2 children. Now, granted, my kids are only 7 and 9, so this is not super applicable right now, but let's pretend that they were 27 and 29 and I became incapacitated and I have a power of attorney that authorizes my daughter to act on my behalf at 29 years old. Do I need a guardianship? Maybe not. But what if there's certain tasks or things that my daughter wants to be able to do on my behalf that the law does not allow her to do unless I specifically state it? In those scenarios, sometimes a power of attorney isn't enough. I will highlight this by saying that attorneys that handle estate planning and that also handle elder law and special needs related matters will have powers of attorney that give your agent all the authority that would be needed to do asset protection planning, tax planning, government benefits planning for you if it were needed. I have more clients than I can count that will come in and they have a power of attorney that their homie, who's a real estate lawyer, had them sign, and that power of attorney is effective. There's nothing wrong with that power of attorney except that mom now is incapacitated, and this power of attorney does not authorize me to, or does not authorize you, the agent, to transfer mom's house to a trust. And if mom's incapacitated already, we're going to court. So, yes, there are situations where a power of attorney may be enough. Sometimes there are situations where it isn't. But again, the situations where it isn't is avoidable. You just got to go to the right place. Funeral instructions. So right now we have forms actually that the state has issued to be able to appoint a funeral and disposition representative. It can be, you can appoint someone in your will or in a form that you sign during your lifetime that's called the appointment of agent to control the funeral and disposition of my remains. Why is this important? You know, the last thing you want is for your kids or for you and your siblings to be over mom's body fighting over whether or not she gonna be cremated or buried because she told you one thing and she told the other one another. I'm using that as a colorful example to say that state law provides an order of priority as to who funeral homes should take instruction from when disposing of someone's remains. If you have not appointed an agent or representative, statutory preference is going to be spouses, of course, then adult children, but it's a majority of adult children. So picking on my own kids, if my husband is no longer able to make the decision for me, and it's between my son and my daughter, if one wants one thing and the other wants another, you know what we don't have? A majority, right? So now we have a whole problem that could have been avoided if I just said, listen to my daughter first and then listen to my son. Just using that as an example. The point is for you to appoint people that you trust and to make the affirmative decision to also communicate those wishes. If the planning position that you're coming to this table tonight from is that you want to know the things to tell your parent or your aunties or your uncles or the people who you have close relationships with, estate planning for a lot of people isn't fun. For people who are aging, sometimes it's very depressing. They don't want to think about how things will proceed and how life will be when they're no longer here. So what I urge families to do when they're having these discussions is to take the weight off of the person, right? To say, hey, look, we're not trying to expedite how quickly we're going to get your stuff. We just want to make sure that we follow your instructions the way we always have since the day we were dropped on this earth, right? We want to be able to continue to fulfill your legacy and what it is that you want to occur based on making some hard decisions up front. The biggest thing that I urge is for people who don't want an equal distribution to tell their children that. I'm about 50-50 between the ones that actually have the gumption, right? See, I didn't use a colorful term, the gumption, to tell their family members, I'm leaving you 20% and your sister 80, right? And then I have others that are like, yeah, by the time they figure it out, I'll be dead. Nobody be mad at me. It'll be fine. We'll move on. But sometimes we can avoid a lot of post-death drama if we're just upfront and honest with our family about where we want things to go. Your will. Wills only control assets titled in your individual name at the time of your death. Accounts that are jointly held or that have beneficiary designations are not governed by your will. So now let's talk about our group of people that like to do it yourself, right? You found a kit online, Susie Orman is hooking you up, you hit up Rocket Lawyer, whatever. I'm not a hater of those things because they don't really change my world too much. But let's say you use any of those, right? You use them, you have an idea as to how assets would be distributed. I recommend that you speak with an attorney to confirm your understanding of what your documents say. An example of this that I have is a client several years ago that came in with this will that she was so proud of that she had drafted herself on one of the platforms. And I didn't give her any opinion about it. I just said, hey, let me know what you think this says. And she told me, I've got all of my bank accounts. I want everything to be evenly divided among my children. Okay, great, no problem. I look at her will. It does not say that. She's got assets that are named specifically. I want bank account 123 to go here. I want bank account 567 to go there. I want my house to go this way. She had all these different distributions that at the end of the day did not accomplish what she thought, which was that her children were being treated equally from a dollars perspective, not just an accounts perspective, right? So big picture is when we're looking at estate planning and we're looking at how someone is structuring their assets. We don't just, it's not enough to have a will that says you want stuff divided in half. Because if all of your accounts are jointly held, your will is toilet paper. It's not going to control anything at your death. It's garbage, right? So having a sense of what your beneficiary designations are, what your joint account designations may be, and how things are titled are critically, critically important, which is why it's in red right here. Beneficiary designations, do not forget about them. They are critically, critically important because they can change ultimately how your estate will be distributed. And it could be distributed differently from what you think your wills say. With this, I just want to highlight this last point here, which is about minors and persons with disabilities. If you have a loved one who is aging, right, and is receiving government benefits or could be receiving government benefits, or you have minor children that you're caring for or grandchildren that you want to leave assets to, it's really important for us to also remember the beneficiary designations that we've set to life insurance. I didn't think I had to tell people in 2025 that a 4-year-old can't manage money, right? Like that seems like an obvious duh. A 4-year-old can't manage money. Yet and still, I'm over here filing court applications for guardianships because a parent passed prematurely when their children were 3 and 5 years old. And now I have life insurance policies that otherwise would be distributed to 3 and 5-year-olds. Like, that's not a thing. If in your wills, however, you have left or you decide to leave assets in trust, the beneficiary designations for your assets that the will does not control should match and should marry that. So that anything that you have set forth in your will is also tied nicely with your assets that your will does not control. So now let's talk about a trust really quick, because that's like the hot topic that we hear about often on TikTok and everywhere else. And I'm sure none of you are taking legal advice from TikTok, but just in case you are, here we go. So a trust is just a legal way to own an asset. It's an agreement between three parties, essentially. However, the contract itself is typically only signed by two of those parties, but it's an agreement that involves three parties. The trust creator, which we call the grantor or the settlor, depending on the state that you're in. The trustee is the person who is entrusted to hold and manage the funds. And then the beneficiary or beneficiaries are the people who can benefit from the trust. So a trust is basically like an invisible box around some stuff. And the way that you get the stuff inside the box is by titling it in the name of the box. Once the stuff is titled in the name of the box, think about the box as being something that can be moved. I want to establish a trust for my children. My children, as I mentioned earlier, are 7 and 9 years old, and I want to give them each $100,000 today. So I'm going to set up one box that says that it's for the benefit of two beneficiaries, and I'm going to fund it with a total of $200,000. I fund that trust by establishing a bank account well, actually, let's not say that. I create the trust. So I'm saying, Crystal is the trust creator. I want to create this trust. I have this money, pretend that it's in this box. I then want Connie to be the trustee because I know that she's not going to let my kids run amok, right? And she's also not going to pay for things I wouldn't pay for. Like my son can't have a new car, right? She could pay for some hockey lessons. That's what he's into. But like, he not getting a car. So Connie is the trustee. So effectively, what's happening is me as the trust creator, I'm handing $200,000 over to Connie. But before I let go of my money, I'm going to have Connie sign a contract. That contract is called a trust agreement. And that contract is going to say, hey, Connie, you're holding my money. Now, I just want you to know this money isn't for me. This money is for my children, the beneficiaries. But you are the person who is going to manage and hold it. Connie, if for some reason your hands fall off though, and you cannot hold this money anymore, Ed, your beloved, cannot hold my money. Okay? At that point, the only person that can hold my money is Tez, right? That's in the trust agreement. And then it says this trust though is going to basically bust when I die. And at that point, I want the money to be held for the separately, right? For my children, or I want it to be distributed to my kids, whatever the terms are. But I set the terms when I create the trust, and the trustee agrees to those terms when she decides to accept control of my money, right? Now, my children are the beneficiaries. What are they able to do? Not a doggone thing. They can't manage the money. They can't hold the money because that wasn't a part of my terms. But what they can do is say to the trustee, hey, Miss Connie, can I take some hockey lessons this month? And Miss Connie can say, oh, sure, Derek, no problem. Yep, I'll make the payment, right? And that's how that goes. But so a trust is just a legal construct of how to own assets and for someone else to manage those funds based on instructions that you set. Now, trusts come in different flavors. We do them for different reasons. So trusts are not cookie cutter. A trust that works for your next door neighbor may not work for you. If someone is creating a trust because they live in New York and they want to avoid the probate process, that's a different type of trust than we would use for somebody who wants to leave money to a child with disabilities. So it is very important to know what our goal is so that we can determine what our trust terms can be. Trust can be revocable or irrevocable. They can be established during our lifetime, or we can have them included in our will. But the moral of this story is they're not cookie cutter. So you do need to know what the purpose is before you say, hey, I want to trust. The first thing that the attorney you meet with should be asking you is, what are you trying to get out of it? If you live in the great state of New Jersey and you say, hey, I want to establish a trust so that my assets are protected, and you're 35, the first question that anyone with sense is going to ask you is, why are you trying to put your money in an irrevocable trust at 35? What you trying to accomplish? Oh, well, I'm a surgeon and I know that at some point in my life I could be sued. Ah, okay. Good reason to establish a trust, but New Jersey's not the place for you because we don't have creditor protection for trusts that you create for yourself, contrary to what TikTok says. So instead, we may have to do more sophisticated planning that pulls in another state for that. However, if someone says to me, hey, I need a trust and I'm really concerned about my asset protection for long-term care planning purposes. I don't want to lose my house. I don't want my money to go to a nursing home. Okay, if that's the case, then I know we're in irrevocable trust land, but I also know that that trust cannot be for the person who's establishing its own benefit. It also cannot name them as a trustee. They cannot have any power or control over those funds. In New Jersey, they cannot have an income right to those funds the way that they could in other states like in New York. So there are more questions that have to be asked. Often, not often, probably 6 times a year, someone will come in my office and they will say, I'm so mad. I'm upset. I want to sue my lawyer. I met with this lady and I told her I wanted a trust and this is what she gave me. And I'm like, okay, why are you mad? Well, because you're telling me that it's not protected if I have to go on Medicaid. Yeah, it's a revocable trust. No, it's the wrong kind of trust. But I told her I wanted to put my house in trust. Well, but did you tell her you were trying to put your house in trust to accomplish Medicaid? Or did you just say you want to put your house in trust? Because now, too sorry, you got to start over. That's a two-part issue, right? One, wasn't necessarily clear what the person wanted, but two, they probably went to the wrong place because the person who they saw didn't ask those questions. So you just want to be mindful of what your goals are. Make sure you communicate them to whomever it is that you're meeting with. So why do people establish trusts? We do it for asset protection. Sometimes we do it for tax planning. But one of the biggest reasons why we do it is because we have special circumstances. If I have people who want to leave money up, you're a child who has done very well for yourself. You have more money than your parents ever thought you were going to have. And you want to make sure that when you die, not only are your kids taken care of, but somebody can make sure that mom and dad are good. If I have someone who wants to pass money up, 100% of the time I'm going to suggest a trust. And the reason is because transferring it up, mom and dad are more likely to need long-term care. And I don't want what you intended to be a blessing for them to then hinder them from tapping into government resources that could allow the money that you're leaving them to stretch longer for whatever their quality of life goals may be. Similarly, if someone has minor children, Crystal not running around here leaving money to minors outright. Never gonna catch me doing that, right? But what you would do is have a trust so that those funds can be protected, not just so that it can be managed while the minor is a minor, but so that it also can have some elements of creditor protection when when that now newly minted adult is an adult and is considering other life things. If you don't do wills, right, then the laws of intestacy decide where your money goes. And the biggest downside to that is for people who are on government benefits, beneficiaries that are on government benefits could potentially lose their eligibility because mom didn't, plan appropriately. I'll use Aretha for that example, right? Like she had at least one child that had some elements of disability that inheriting money directly as opposed to in trust would disqualify them for benefits. So you've got your estate plan, you've got the setup, right? What are the things that could bankrupt us during lifetime? Taxes and the cost of long-term care. You will hear at the next session in December, I think it's December 16th, but the ladies are going to drop it in the chat if I got that date wrong. What the costs of care are, and it can be very, very expensive. And so one of the things that people will look to do is to expedite eligibility for benefits so that they can ensure that the assets that they collected during their lifetime and that they invested in while they were ultimately living life and raising their children can ultimately pass to their generations 2, 3, charities, or wherever they want it to go. When we're thinking about planning for long-term care, just to debunk a myth, Medicare does not cover the cost of long-term care, but Medicare does cover rehab for a limited period of time if it needs to be done in a skilled nursing facility. Ultimately, the government benefits that people are looking to tap into in order to slow down the burn rate of what they truly want to benefit their family is by looking at both benefits from the Medicaid agency as well as the Veterans Administration. For veterans and spouses of veterans who may be joining us tonight, thank you so much for your service. I am from Fayetteville, North Carolina, home of the 82nd Airborne Division. So I understand the sacrifice that you make for your families, and there are benefits and services available that with proper planning can be tapped into to ensure that the things that you've collected ultimately pass to the people that you want. The biggest thing to note on this slide before I go to the final slide is that to qualify for Medicaid, it is a multi-pronged test. But the last requirement is that the Medicaid agency be able to see how you've spent your money for a 5-year period. And roughly for every this year, $12,000 and $12,250 that you give away, it equals 1 month of no Medicaid. Essentially, what that means is that people are penalized by protecting assets, right? So what we try to do is to protect assets in advance, 5 years in advance if we can, and we use trusts and other mechanisms to accomplish that. Unlike your estate planning, which you heard me earlier say, I got no problem with the do-it-yourself tools for estate planning. You absolutely do not want a DIY asset protection planning for purposes of tapping into government benefits, because you could inadvertently disqualify yourself for the rest of your life. So we don't want that to happen. There are certain exemptions to the asset transfer rules. There are ways that we can expedite eligibility, but suffice it to say, for a married couple, for the most part, we can shift assets to the well spouse through some complex planning using annuities. However, for single individuals, or if I have a married couple that we need to apply at the same time, we may also, in a crisis, have the ability to protect about half of whatever their joint assets are at that time. That said, planning in advance, 5 years in advance in particular, typically provides us the greatest asset protection opportunity because we're able to set it aside while at the same time still being able to use our house and not be kicked out of it and still have access to the day-to-day things that we need, while at the same time having the ability to shelter assets to not have those exposed to care at a future time. So with that, I'm going to flip to the chat really quickly to see the questions that I may have missed. And then I will also open up to anyone else who has something that they didn't put in here already. So one of the questions is, are there strategies for estate planning and trust to protect real estate and assets of grandparents away from a daughter's abusive ex companion? But still being able to have daughter and then grandson inherit. Yeah. So There are several ways we can protect real estate, but the greatest way to protect real estate is through trusts. Now, let me say this. We do not, I know everybody's loved one, parent, your godmama, your friends, right? They say, don't cut off your nose to spite your face, right? It's the same concept in estate planning and asset protection planning. I don't want to accomplish a Medicaid goal by creating a tax problem. So those two always have to come together. And when we're dealing with real estate, the way that we're able to solve three problems, the estate planning element of where the assets should go at death, making sure that we do it in a way that's tax efficient, but also doing it in a way that would not disqualify us for government benefits. It would not have a lien basically imposed on property at our death. We do that by way of trusts. When we're using trusts, we do oftentimes give the trust creator a long-term lease, essentially, like a right to continue to reside in the property. Sometimes we'll do that contractually. Sometimes we'll do that by deed. It really just depends on what the circumstances are. But that's a long way to answer your question of yes. So then the next question was, when it comes to young children, in the event that both parents have passed, can you designate someone to be guardian? Yes, 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 yes. And someone else to make financial decisions? Yes, you can. So this is where I say it's Burger King. You can have it your way. And there's no right or wrong way to think about this. If I'm going to pick on my own estate planning, because I'm not going to, talk a walk that I wouldn't be willing to do. In my personal estate planning, the guardian and the trustee are the same person. I trust them immensely, and I want them to have immediate access to money for the things that my children need. However, many people have the appointments be different. They say that the person who I know is going to care for my kid the best, I don't really want them to have unfettered access to the money. I want to keep it separate. I want to have checks and balances. Whatever you want can be accomplished as long as you do it in your will. The appointment of a guardian must be in the will.
Crystal, there's one question prior to that. That can funeral instructions be in a will, or does it have to be a separate document?
Either one is fine.
Okay.
We now have a separate form. If you don't do the separate form, you can do it by stating it in the will. Preference would be the separate form because then you won't have to give the will to the funeral home. You may not even have it readily available right then, right?
Mhm.
So then the next one, that was the young kids, I think, not an attorney, but yeah, okay. Is the trustee and the executor of the estate one and the same? No. So the executor is the person who is authorized to act on your behalf at your death to make decisions for you based on the assets titled in your individual name at the time of your death. So if I have a bank account that has $100,000 in it, but everything else I own was already transferred to a trust that Connie is the trustee of, what job does my executor have? My executor is only going to be in control of the account that was titled to me in my individual name at the time of my death, that 100,000 account. The trustee, however, is the person responsible for managing the money that I already had in trust. So can they be the same person? Yes, if you choose to name the same person in both roles, but they'd be wearing different hats. I'll take it and use another example. I have a will that says at the death of my husband and I, my assets are divided equally among our children in separate trusts for their benefit. The executors of our estate are going to have the responsibility of collecting our assets, paying our final debts, filing our final income tax return, and paying the estate beneficiaries. Who are the estate beneficiaries? The estate beneficiaries are not my kids, because I just told you that my will says that it is to be distributed 50% to each trust for my kids. So what that would mean is my executor is writing a check to the trustee of Eva's trust and the trustee of Derek's trust. Can a trust created in New Jersey be implemented for children, grandchildren in another state? The answer to that is yes, with one caveat. If the beneficiary is a person with disabilities. If the beneficiary is a person that may need to apply for government benefits for themselves, a grandchild with autism, right? A cousin with Down syndrome. Those are scenarios where you should engage a local attorney in the state that the beneficiary resides in to ensure that there's nothing in the New Jersey trust that would be a problem in your example for New York Medicaid. But other than that example, it would be totally fine. Then the next question was, can you name common mistakes that attorneys may make in putting in estate planning? Yes. Giving away. So if I'm talking to an attorney, then I'll use attorney terms, which is giving away all the assets pre the residue. What that means is whenever you have an estate plan, things that you specifically give away go first. So let's say that you've decided, you know what, I'm going to pick on myself. I've decided in my will that I want $100,000 to pass to the Cathedral International, to my church. Okay. And let's say today that represents 10% of my estate. But I said I give the cathedral $100,000. 40 years from now, I die and I don't have but $50,000 to my name. I have just disinherited my children because the 100,000 that I designated to the church is to be paid first for whatever amount is left, right? So again, the mechanics of the estate administration is an important context when preparing wills. Okay. Then can a parent exclude a son? Absolutely. Can a parent exclude a son-in-law or daughter-in-law from a trust? Yes. And most of my clients do a trust for that sole purpose. The only reason why they want their kids' money to be in trust is so that their no good spouse or the spouse that you love dearly, but you didn't birth them, nor did you adopt them, so they're not your problem. You don't want them to inherit money who they then give to their families. So yes, trusts are a really, really, really good way to protect assets, not just in making sure that people are managing money correctly, but it's really in shielding assets from being able to be touched by outside people. Do you need to always present the original will? Yes. So to probate a will, you must have the original. If you do not have the original, you have to obtain a court order. If you don't have the original, to obtain that court order, let's say all you have is a copy, you have to prove by clear and convincing evidence that the testator did not destroy the will. Because one way to revoke a will is to just rip it up. So it's a super, super high standard. If you don't have the original will, you have a copy, but you don't have a provable reason why the original is not available, you're probably not going to get that copy admitted to probate by the court. How can a 5-year inherit money? How can a 5-year-old inherit money in real estate when parents pass away? What do you write in a trust to designate the 5-year-old not to have full authority over inheritance until 35? It would be a trust. What do you write to only allow certain expenses, such as medical expenses and education, without being abused? Also a trust. So the way that a 5-year-old ends up inheriting money is by having a will. Let's say, using my example, my husband and I came back from our honeymoons. We didn't have kids yet. Let's say, though it didn't say this, but let's say that the will said, at my death, it passes to my spouse. If my spouse isn't living, then to my descendants per stirpes. That means equally to my children. If one of them passes before me, their share goes to their kids. If that's all I say, I haven't provided a trust for my child. So if I die prematurely before my kids are 18, then the assets ultimately are going to pass directly to them. Now, it wouldn't pass directly to them in real life. If you leave money to a minor child, short of us going to court to ask the court to establish a trust, or short of us going to court to ask the court to actually, it's the only thing you can really do is ask the court to establish a trust. Other than that, it's going to be paid to the surrogate's office in their custodial account, which means that until the child is 18 years old, there would need to be basically court petitions to request distributions from those funds for the child. So really quickly, after 9/11, the New Jersey legislature passed a law that allows the court to establish a trust for a minor child whose parent did not have the ability to do it during their lifetime. So in this example that was just asked of me about the 5-year-old, we would be going to court. We would ask the court to establish a trust for that child. And the court rule says that they could establish a trust that would leave 1/3 of the money at 25, half the balance at 30, and the remaining balance at 35. The caveat to that law, however, is that you need two individuals to serve as trustee together or have a corporate trustee. And the second consideration is that the child must be able to petition the court at 18 to get their money if that's what they choose to do. So I know we covered a lot. I think I answered all of the questions in the chat, and it is 8 o'clock on the nose. I'm gonna pass it over to Miss Connie, Miss Tez, or Miss Maeghan.
Awesome, awesome. Thank you so much, Crystal. You definitely covered a lot and clarified a lot. Someone asked for your information, so I've shared a link here. I love that you went, most of us have been to some type of estate planning workshop, but I feel like this went a little bit more in depth and had some specific guidance. I already have an action item. I need to take these kids as off beneficiaries of these accounts.
Correct. Name their trust instead.
Yes, yes, yes. So thank you so much. So I hope this was helpful to all. And as Crystal mentioned, we do have, so this is going to be a series, y'all. So some months ago, maybe a year ago, we had a panel. We had different professionals come in, and our goal was to kind of have like a 360 view of, the planning stage and different professionals that services or supports the sandwich generation. We thought it'd be helpful to go a little bit more in depth with one professional at a time. And this is our launch. And so we thank you for that. The next one, I've already shared the link, and I'll share it again, is going to focus on, so a lot of people, right, as our parents or elderly age, we don't want to put them in a home, or they don't want to be put in a home, right? And so the first step of that is identifying, okay, well, what does staying home look like, right? So what are the emotional, financial needs? And our expert, Maeghan Scott, who provides in-home care, is going to speak to us on December 16th about this. And we're going to go into what does it really mean, right? What does it take to have an in-home care and consider the financial, emotional, and health aspects. So that way you're prepared and you can then think about if that's something that makes sense for your loved ones, or if you need to consider something different. And of course, we'll have a part 3 about what that different model, will look like. So that's sort of how we're gonna go along. But if there are other topics that you want to hear about, please let us know. And also, Maeghan and Connie, if you can also share your links where people can find you, should any of the folks participating have questions, that would be great as well. I'll add mine here. Yeah, anybody else have anything to add? Any burning questions that we haven't answered? Oh, Miss Edwards, we just shared. Monique, do you see it? Her link? Both Maeghan and Connie have shared. Shanita said, excellent presentation. I'm really looking forward to the second series. Thank you. So that we've just shared the link. Make sure you register and you let other people know. Awesome. All right. Thank you so much, guys. We appreciate you staying with us, Crystal. That was really great. We appreciate your time. Thank you, Nicole. And we will see you at the next one in December. All right.
Have a
Take
good night.
care.
Great. Thank you, everybody.